These 29 states are quietly billing families after a parent dies and using that bill to take the family home. Before I tell you exactly which states do this and how to find out if yours is one of them, I need to explain something that most financial advisors never warn their clients about. Because if you or your parents ever need a nursing home, this one rule could cost your family everything they spent a lifetime building. The average nursing home in America costs $9,000 a month. That is $108,000 a year. Most people do not have that kind of money sitting in a savings account, so they do what the government tells them to do. They apply for Medicaid, and Medicaid pays. It pays the nursing home bill. It pays the rehab cost. It pays the skilled nursing facility. For years sometimes, and families breathe a sigh of relief because they think the worst is over. But here is what nobody tells you at the Medicaid office. Federal law requires every state in America to have something called a Medicaid Estate Recovery Program. The acronym is MERP, and what MERP does is simple. It tracks every dollar Medicaid spent on your parent or your spouse, and when that person dies, the state sends a legal claim to the estate, a bill, for every single cent Medicaid ever paid. That bill is not a suggestion. It is not optional. It is a legal lien against whatever is left, against the house, against the bank account, against the only asset most middle-class families have. 29 states enforce this program aggressively, not passively. Not only when families are wealthy, aggressively. Against families who did everything right, paid their taxes for 40 years, and assumed Medicaid was a benefit they had earned through a lifetime of contributions. It was not a benefit, it was a loan, and the collateral was the house. Here is how the mechanism works step by step. Your parent enters a nursing home. The monthly cost is $9,000. Their savings get spent down to the Medicaid eligibility limit, which in most states is $2,000 in countable assets. Once they hit that floor, Medicaid activates and covers the nursing home bill from that point forward. But from the moment Medicaid starts paying, a government ledger opens. Every payment is logged, every month, every year of care. The state records the running total with the precision of an accountant who knows they will collect later. Then your parent dies. The estate opens, the house is still there. It may be the only significant asset remaining, and within weeks, sometimes months, the state files a recovery claim against that estate for the full amount Medicaid paid. In Massachusetts, the average recovery claim runs over $90,000. In Oregon, the state has recovered over $1 billion total since the program launched. In Iowa, families have lost homes that were in the family for 3 generations because nobody told them a clock started running the day Medicaid wrote the first check. Now here is where it gets significantly worse. And this is the detail that catches most families completely off guard, even when they have heard of estate recovery. There are 2 types of Medicaid estate recovery. The first type only pursues probate assets. Those are assets that pass through the court process after death. That alone is serious enough. But 21 states go further. They use what is called expanded estate recovery. That means they pursue assets that normally bypass probate entirely. Joint bank accounts, jointly held property, assets held in a revocable living trust. In some states, even certain retirement accounts transfer on death designations. In expanded estate recovery states, the common family strategy of adding a child's name to the deed to avoid probate does not protect the home. The state anticipated that exact move. The law closes the door before families even know the door existed. Let me give you the specific states. The states with the most aggressive estate recovery enforcement right now are Massachusetts, Oregon, Washington, Iowa, Minnesota, Wisconsin, Michigan, Ohio, Pennsylvania, Colorado, Idaho, Montana, Nevada, New Mexico, North Dakota, South Dakota, Wyoming, Nebraska, Kansas, Missouri, Arkansas, Mississippi, Alabama, Tennessee, West Virginia, Virginia, Maine, Vermont, and Connecticut. That is 29 states. 29 states where the home your parents spent their life paying off is directly at risk after a Medicaid-funded nursing home stay. If your state is not on that list, do not assume you are safe. Every state has some form of estate recovery. States not on this list have the program, but apply it less aggressively or carry broader hardship exemptions. That can change with one legislative session or one budget shortfall. Several states that were quiet a decade ago became aggressive collectors in the last 3 years as Medicaid costs rose and state budgets tightened. Now, I need to explain the look-back period because this is the rule that destroys families who thought they were being proactive and smart. Federal Medicaid law includes a 60-month look-back period, 5 years. When someone applies for Medicaid, the state pulls every financial transaction going back 5 full years. Every gift, every transfer, every dollar that moved out of that person's accounts or out of their name. If your parent gave money to a child or grandchild within those 5 years, Medicaid treats that transfer as improper. And for every dollar transferred, Medicaid calculates a penalty period, a window of time during which Medicaid will not pay for nursing home care. During that penalty period, the family is responsible for the entire nursing home bill out of pocket. Here is what that looks like with a real number. Say your mother transferred $50,000 to you 3 years ago to help with a house down payment. 2 years later, she falls, breaks her hip, and needs nursing home care. She applies for Medicaid. The state finds that transfer in the look-back review. In a state where the average nursing home costs $9,000 a month, that $50,000 gift generates a penalty period of approximately 5.5 months. 5.5 months where Medicaid pays nothing. Your family owes $49,500 to the nursing home before Medicaid will activate. The gift that was meant to help your family now creates a debt that nearly cancels it out entirely, and you still have to pay it before Medicaid steps in. There is a family in Ohio, the kind of family this law was not supposed to affect. The father was a retired auto worker. He bought his home in 1982. He was careful with money his entire life. He entered a nursing home in 2021, spent down his savings to the Medicaid threshold, and passed away in 2023 after 2 years of care. The Medicaid recovery claim against his estate was $167,000. The house was worth $190,000. His 2 adult children, both working people with their own mortgages and families, had no idea this was coming. They had never heard of MERP. Nobody at the Medicaid office mentioned it. Nobody at the nursing home mentioned it. They found out when the state filed its claim after probate opened. They sold the house. Ohio alone recovered over $42 million from estates in 2023, and Ohio does not even rank among the most aggressive recovery states. Understanding exactly what triggers a claim matters because the timing and sequence of events determines what options families still have. The first trigger is Medicaid paying for nursing home care, long-term care facility care, or home and community-based waiver services. Not all Medicaid coverage triggers recovery, specifically the long-term care programs. The second trigger is the recipient dying while owning property in their name or in an estate the state can legally reach. The third trigger in expanded estate recovery states is dying with assets that transfer outside of probate, but that the state has defined as recoverable under its expanded definition: a joint account, a trust, a deed with a surviving co-owner. Here is what most families miss entirely. In many states, the recovery claim does not have to be filed immediately after death. The state can wait. In some states, the clock on their recovery right does not start until a probate estate is formally opened. If no estate is opened because the family assumes there is nothing to probate, the state claim can sit dormant for years. Some families discover the lien only when they try to sell the property 5 or 10 years later. The lien is still valid. The debt is still owed, with interest in some states. Now let me address the hardship exemptions because families ask about these after they hear about recovery. Federal law requires every state to have a hardship waiver process. The problem is that these waivers are narrow, difficult to obtain, and inconsistently applied depending on the state and the caseworker. The most common hardship exemptions that actually get approved are these. First, if a surviving spouse is still alive, recovery is deferred until after the spouse also dies. Second, if a dependent child under the age of 21 lives in the home, recovery is deferred. Third, if a blind or permanently disabled child of any age lives in the home, recovery may be deferred or waived entirely. Fourth, a sibling who lived in the home for at least 1 year before the Medicaid recipient entered nursing care and who already held an equity interest in the property may qualify for protection. Notice what is not on that list. An adult child who lived in the home but was not providing documented care, an adult child who lives nearby but in a separate residence, a grandchild who was close to the grandparent, a family that simply cannot afford to pay the claim without severe financial hardship. None of those automatically qualify for a waiver. The process requires a formal application, detailed documentation, and a state agency review that operates on its own timeline and with its own standards. States deny more waiver applications than they approve. So what can families actually do? because this is where most coverage on this topic becomes too vague to be useful. The most effective legal tool for protecting a home from Medicaid estate recovery is an irrevocable Medicaid asset protection trust, not a standard revocable living trust. A revocable trust does not protect assets from Medicaid recovery in most states because the grantor retains control, and Medicaid treats retained control assets as still belonging to the applicant. The trust must be irrevocable and specifically structured for Medicaid planning purposes. The critical rule is that the trust must be funded at least 5 years before the Medicaid application is ever filed. That is the look-back window again. If the home is transferred into the trust inside that 5-year period, Medicaid can still count it as an improper transfer and impose a penalty. But if the trust was funded and the 5-year clock ran out before Medicaid was ever needed, the home is protected. The state recovery program has no legal claim against it. The family keeps the house. This is why elder law attorneys say the best time to do Medicaid planning is when the person is healthy, not when the hospital is already calling, not when the nursing home social worker is handing over Medicaid application paperwork. By that point, the 5-year window has not run. There is no protection available through a trust in the short term. The second tool is a life estate deed, sometimes called a Lady Bird deed in states that recognize it. A Lady Bird deed lets a parent keep full control of the home during their lifetime, including the right to sell or refinance it, but transfers ownership automatically to named beneficiaries at death outside the probate process. In states that only pursue probate estate recovery, a properly executed Lady Bird deed can protect the home because the transfer happens outside probate. The house never enters the estate the state has the right to claim against. But in expanded estate recovery states, a Lady Bird deed may not provide full protection. If the state has written non-probate transfers into its recoverable estate definition, the claim follows the asset regardless of how the ownership transferred. That is why knowing specifically whether your state uses probate-only recovery or expanded recovery is not a detail. It is the entire question. The third strategy is less known but legitimate in the right circumstances. It is called the caregiver-child exception. If an adult child lived in the family home with a Medicaid applicant for at least 2 years immediately before that person entered a nursing home, and that child provided care during those 2 years that delayed or prevented the need for nursing home placement, the parent can transfer the home to that child without triggering the look-back penalty. The transfer is exempt. This exception exists in federal Medicaid law and every state must recognize it. But the documentation requirements are strict. You need evidence the child actually resided in the home, evidence the parent met the clinical threshold for nursing home level of care during the caregiving period, evidence the child's care directly delayed institutional placement, and the transfer has to occur before the Medicaid application is filed, not after. Families who qualify and document this correctly have protected homes worth $200,000, $300,000 more. Families who attempt it without proper records, or after Medicaid has already been applied for, lose the exemption and face the look-back penalty on the full transfer. Here is the reframe that ties all of this together. The Medicaid Estate Recovery Program is not a loophole that states discovered. It is not an overzealous interpretation of the law. Congress designed it in 1993 and wrote it directly into federal statute. Every state was required to implement it as a condition of receiving federal Medicaid funding. The explicit purpose was to shift the cost of nursing home care from the federal government back to the estates of people who use the program. The families who lose homes to estate recovery are not people who made financial mistakes. They are people who made decisions without complete information. They did not know a government ledger opened the day Medicaid wrote the first check. They did not know the look-back period could claw back gifts from years earlier. They did not know their state pursued assets outside of probate. Nobody sat them down and explained it. The protection from this law works exactly one way. You have to know about it before it applies to you. If your parents are over 60 and own a home, that conversation needs to happen now, not when the nursing home is already involved, not when the Medicaid caseworker is reviewing applications. Now, while the 5-year clock can run, while a trust can be properly funded, while a deed can be restructured, while the caregiver exception can still be set up correctly. Find an elder law attorney this week, not a general estate attorney, an elder law attorney who specifically handles Medicaid planning. Ask them 2 questions. Does your state use expanded estate recovery or probate-only recovery? And how much time do you still have to protect the assets that remain? Those two questions are the difference between your family keeping what your parents built and a state agency filing a claim the week after the funeral.